If they accidentally did this, it's probably not fraud. If a miscommunication caused this, also an accident or mistake, it's probably not fraud. But if it's intentional, it's probably fraud. So we'll find out here. At least they didn't allege RICO. This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. All right, so this has been filed, but does not appear to have been officially served on Nike. So let's just remember that this might be over before it's begun. This might be all that we ever see of this. And so definitely relish this while you can. This is the case of Leonard v. Nike. No, I'm not Leonard, I'm Mr. French. This is the case of Kawhi Leonard v. Nike. Kawhi Leonard is, I hope I'm pronouncing it right, is a basketball player in the NBA, I believe. I think it's the NBA because I don't think an NCAA player could do this sort of exploitation of their self. First, let me show you what we're talking about because at least we'll get that interesting part done. Kawhi Leonard has made a logo. This is a logo made from his own hand. Like literally he put his hand down and traced it and then had the tracing turned into this logo, which he calls the Claw. And he has sued Nike over their use of the Claw. So let's take a look at this. This is Kawhi Leonard in the United States District Court for the Southern District of California. In 2011, just after being drafted into the NBA, Kawhi Leonard authored a unique logo that included elements that were meaningful and unique to him. Leonard traced his notably large hand, and inside the hand drew stylized versions of his initials KL and the number that he had worn for much of his career, number 2. Let me go back and look at that again. So the number 2 there is the index finger, it looks like. The drawing Leonard authored was an extension and continuation of drawings he had been creating since early in his college career. Several years later, as part of an endorsement deal with Nike, Leonard allowed Nike to use on certain merchandise the logo he created while Leonard continued to use the logo on non-Nike goods. Unbeknownst to Leonard, and without his consent, Nike filed an application for copyright registration of his logo and falsely represented in the application that Nike had authored the logo. Leonard intends to use the logo on clothing lines, footwear, on products, and among other things in connection with sports camps and charity functions, but Nike explicitly has objected to such uses. As set forth below, Leonard brings this action seeking a declaratory judgment of non-infringement and that Leonard is the author of the logo, and Nike, in registering for copyright of his logo, committed fraud on the Copyright Office. Kawhi Leonard is an American professional basketball player. At all times mentioned, was a resident of the county of San Diego. After graduating high school, Leonard went on to play basketball for San Diego State University before entering the 2011 NBA draft. Leonard was initially selected by the Indiana Pacers, but was traded on draft night to the San Antonio Spurs. Leonard played for the Spurs for 7 seasons, including the team's NBA championship season in 2014. At the conclusion of the NBA Finals in 2014, Leonard was named NBA Finals MVP, the third youngest player to win the award. In 2018, Leonard was traded to the Raptors. Leonard is known for his extremely large hands. Throughout his career, spectators have noticed Leonard's large hands, and they are often described as contributing to his success as a player. Leonard has worn jersey number 2 through much of his career, and at times before that, the number 22. Since at least his college years, Leonard contemplated and conceived of ideas for a personal logo which would be unique to him and reflect something meaningful relating to his own image. In late December 2011-2012, Leonard refined a logo he had been creating for several years that encompassed his large and powerful hands, his initials, and his jersey number, the Leonard logo. Okay, they're getting a little too on about these large and powerful hands. Like, we get it, they're hands. The large and powerful parts get a little creepy. Leonard shared his original work of authorship with family and friends, solicited the advice and expertise of a creative designer, received comments and suggestions, and made modifications to his design. In other words, a lot of work went into this. Leonard signed with Nike a men's pro basketball contract, October 26, 2011. The Nike agreement term was from 2011 to 2014 and thereafter extended in a series of agreements that expired September 30th, 2018. The purpose of the agreement was for Leonard to provide personal services and expertise in the sport of professional basketball and endorsement of the Nike brand and use of Nike products. At some point during the Nike agreement, Nike began discussions with Leonard about creating a unique logo to affix to merchandise and to be sold under the Nike agreement. Nike provided to Leonard its ideas for modifying the logo Leonard had designed. Leonard, for the most part, rejected Nike's concepts and instead forwarded to Nike the Leonard logo, which Leonard said he would permit Nike to use during the term of the agreement. Nike reviewed the Leonard logo, modified it, and returned pro formas to Leonard in the spring of 2014. I think those are like examples or proposals. He rejected those proposals as well. In early summer 2014, Nike provided additional proposals. He accepted one of the proposals and granted Nike permission to affix that logo based on the Leonard logo on Nike merchandise during the term of the agreement. Nike confirmed that the agreed-upon logo had not been previously registered by any third party. At the same time, Leonard's representatives confirmed that Leonard continued to own the Leonard logo. Leonard never transferred the rights to the Leonard logo to Nike. Conversely, as the many communications, including text and emails, show, Leonard permitted Nike to use the Leonard logo for their mutual benefit and for the specific purpose of effectuating the Nike agreement for the term of the contract. Indeed, Nike representatives recognized Leonard's rights to the Leonard logo, referred to it as the Kawhi logo in written communications with Leonard. Leonard, without dispute or challenge from Nike, continued to use the logo on non-Nike goods, including apparel and merchandise used for basketball camps, charity events, even while Nike was affixing the same logo or similar logo to Nike merchandise. Consistent with Nike's position as a party without any ownership in the logo, Nike refused to act several times when Leonard's representative learned that third parties were using the Leonard logo without authorization. So Nike did not try and enforce its copyright, even though third parties were using the logo without permission. That's also evidence that Nike did not own the logo. Without Leonard's knowledge or consent, Nike filed an application with the U.S. Copyright Office to register the Kawhi Leonard logo. May 11th, 2017, the application was granted, registration number VA 2097900. That's a cool number, actually. On the application, Nike claimed authorship of the logo and rights and permissions to the Leonard logo. Further, Nike claimed the Leonard logo was authored in 2014 and first published October 28, 2014. Nike's claim to ownership of the Leonard logo is premised on the false representations Nike made in its copyright application that it authored the logo. Nike never notified Leonard of its intention to attempt to copyright the Leonard logo, nor did it notify Leonard when the copyright was awarded. On November 9th, 2017, Leonard applied for and subsequently received registration of 2 trademarks in 3 different categories of registration, consisting of and inspired by Leonard's creation of the Leonard logo. One on image of his hand, his initials and jersey number, and a second logo based on letters and numbers corresponding to his initials and jersey number from here on after the Leonard trademarks. As set forth above, Leonard has been developing, authored, etc., and continued to use these logos on products not made by Nike, while also permitting Nike to borrow the Leonard logo. Leonard intends in the near future to use this logo on apparel and footwear that he is actively developing and intends to bring to market and affix on items he intends to distribute in connection with sports camps and charity events. Use of the Leonard logo is vital to Leonard's ability to continue to grow his brand and expand both his commercial reach and influence with charities with which he's involved. On December 21st, 2018, Nike's VP of Global Counsel for Sports Marketing, John Matarazzo, wrote to one of Leonard's representatives stating that Nike owns the Leonard logo pursuant to the Nike agreement and Nike's copyright registration. Matarazzo demanded that Leonard cease using the Leonard logo on non-Nike merchandise. January 30th this year, Leonard's counsel responded by requesting Nike rescind its copyrights in the Leonard logo and informed Nike that Leonard intended to continue to use the logo and trademarks on non-Nike merchandise and might affix the logo and trademark to shoes he would be wearing as a player for the Raptors. March 11th, Nike responded that it owns all intellectual property rights in the Leonard logo and demands Leonard immediately cease and desist from what Nike claimed was the unauthorized use of the Leonard logo. And then he asks for a claim of relief, a declaratory judgment of non-infringement, which really should be enough to then convince Nike that they don't own it. And maybe he doesn't need to further ask for an injunction or something like that until he at least gets this, and Nike then continues to stonewall. So he asks for a declaratory judgment that he is the sole author of the logo, that his use of the logo does not infringe on Nike, that he may claim and possess any rights to the logo, that the defendant committed fraud by registering the logo. So they're going to basically end up having a fraud trial. Now, here's one problem. If I was Nike, I'd be filing a motion to strike the fraud request, because fraud requires a pleading with particularity, usually. It's usually a state law, so it would have to be California state law. And I don't know California state law on this, but Pennsylvania state law requires you to plead fraud with particularity. Now, maybe this is particular enough. And maybe that's enough. But you would normally have like a separate section where you put forth all of the details of the fraud. Because if they accidentally did this, it's probably not fraud. If a miscommunication caused this, also an accident or mistake, it's probably not fraud. But if it's intentional, it's probably fraud. So we'll find out here. At least they didn't allege RICO. But chink. What do you think of that? Let us know in the comments below. We will follow this and report back to you on the... it's truly unbelievable sometimes. Now, how could this be all completely different than how Mr. Leonard, which is a weird thing to hear me say because my mom calls me Mr. Leonard sometimes. How could this all be, in favor of Nike? Well, if Mr. Leonard somehow signed this agreement and there's a clause in this agreement that says, I assign all rights, property, interest in the Leonard logo, or other somewhat similar effective statement, then yeah, he's wrong. But he wouldn't have done that, and his lawyers wouldn't have filed this without checking on that document and that license. So I don't think that's happened. But there's a chance that Nike could come back and say, oh, yeah, look at this clause here. That meant that you signed away your rights. But they'd have to be right. The judge would have to agree. So hopefully this gets resolved without all of that, because I don't see this benefiting Nike in any way. And I really see this only as Streisand affecting Kawhi Leonard. I didn't know who Kawhi Leonard was anymore. Now I find out he's actually a really nice guy so far, and that he's got this logo and that he helps kids and works with charities. I want to know more about this guy. So thank you, Nike. I didn't know about that before. I will continue to not buy Nike merchandise, and I will now support Kawhi Leonard. So I appreciate the Streisand effect there. That is our show. Thank you to our supporters for the month of June. This channel would not exist without your financial support. At the $50 level, thank you to John Steele, Gavin Barnard, Kyle Mudrak, Eevi, Michael Pearce, Terry Crisp, Richard Fournier, Spirit Bear, Jan Negrey, Daniel Perez, Aspernari, and Snorre Wisotzky. Thank you very much for your support at the $50 level. And thank you to the $5 plus supporters scrolling on the LED panel behind me and in the description below. You're all in the description below. And thank you very much for your support. We'll drop these stories about once per day, so you can expect that if you click that bell, you'll get about one Lawful Masses story per day. Otherwise, just click the subscription button and you'll get us in your feed from time to time, and hopefully you give us a click. So if you have any particular stories you'd like to see us do one of these analyses on or reviews on, drop us a line. You can find us at Twitter at Leonard J. French, or you can find us on Discord. I think there's a link in the description. And you can email us at business@lawfulmasses.com. I think Brandon checks that one. So anyway, thank you for joining me. I am Leonard French, your favorite copyright attorney. I will see you in the videos that drop. Have a great second week of June. I love you all. Bye.